Right. Okay. So thank you all for joining us tonight for Thurgood Marshall, Trailblazing Civil Rights Victory in Montgomery County. And we are so fortunate to have with us our presenter, our return presenter, I might add, Ralph Buglass. I got that right, I hope.
Yes, indeed.
Yes. Here we are starting off with Black History Month. And as many of you probably know, if you've watched some of Ralph's presentations before, he's a frequent speaker for Montgomery History, the Historic Society, and a volunteer researcher for Peerless Rockville. He's an author, historian, and teacher, and we're very fortunate to have him help us tonight to learn about this important case. So thank you very much, Ralph, and go ahead and start whenever you're ready.
All right, thank you, Maria. It's a pleasure to be back with you all, Poolesville seniors. And tonight, as Maria said, to kick off Black History Month, a very local story here in Montgomery County, but with big national significance, because the case that I will tell you about, while not very well known, was part of the lead up to the very important Brown versus Board of Education decision by the Supreme Court in 1954. Has been hailed as a landmark decision. Of course, the court ruled unanimously that school segregation, as was practiced throughout the South, what violated the Constitution, was unconstitutional. And the case brought by the NAACP and its chief attorney, Thurgood Marshall. The history of it is quite involved. This book is something of the definitive history of it. I have it right here. It's something like 800 pages. And the book notes that the case marked the turning point in America's willingness to face the consequences of centuries of racial discrimination. And while I describe the book as the definitive history of the Brown versus Board of Education decision, the local case that I'm going to tell you about is not in the book at all. It's really only with historical hindsight and pretty much in recent years, as a result of research, in particular by a professor at the University of Maryland Law School, that he has pinpointed this case as being very significant, one of the earliest cases that the NAACP brought in order to build up to the ultimately challenging school segregation writ large and bringing the important case to the U.S. Supreme Court. Now, I don't want to get too far into the legal weeds, but I'm going to show you a video. So as background for just a short video, as a background for that, I should say that the Brown versus Board of Education decision overturned an 1896 precedent, which you probably heard about, of Plessy versus Ferguson. And it was an earlier case before the Supreme Court in which the court essentially enshrined into law the so-called separate but equal doctrine. That is, that segregation was constitutional, provided the facilities provided for whites as opposed to the facilities provided for Black citizens were equal. But of course, we know that that was seldom the case. And so better than I can explain the significance of Brown versus Board of Education, I'm going to show this short video. It starts with a current Supreme Court justice, who I hope you recognize. And so she's just going to mention the shorthand version. She just says Brown overturned the Plessy decision.
On May 17, 1954, the Supreme Court handed down the Brown versus Board of Education decision to desegregate America's public schools, signaling the beginning of the end of legal segregation.
The court was able and willing to say, okay, it's time to overrule Plessy, to overrule separate but equal. The court was ready to do that, in large part because Thurgood Marshall had made the court ready to do that. The Supreme Court would not have decided Brown v. Board on its own in a vacuum. This court decided Brown v. Board because lawyers led by Thurgood Marshall, I mean really led by Thurgood Marshall, brought cases to the court which finally made the court understand that this was their constitutional duty.
They had their own plan, their own architecture, their own aspiration about how they were trying to renovate American society, and they managed to do it.
The moment Brown was decided, segregation in every aspect of American life, the writing was on the wall and the days were numbered.
That is, I think, the most profound story in American law in the 20th century.
I don't know of a legal accomplishment in this country that's greater.
And now you'll hear Thurgood Marshall.
After all these years, the struggle is far from over. Society continues to hold out unfilled promises and unrealized aspirations. The incongruity of slavery in a nation conceived in liberty and dedicated to the equality of all men floated through our history like an iceberg, awaiting the inevitable collision.
So there you heard the Brown decision, very significant in and of itself, and Thurgood Marshall, a legendary figure in the law as well. The two women who were interviewed, I hope you recognize Justice Elena Kagan. She was described as a colleague. They actually never served on the court together, though interestingly, Elena Kagan served as a law clerk to Thurgood Marshall when he was on the bench, and Kimberly Crenshaw, a professor at law schools on both coasts. Thurgood Marshall, of course, became the first African-American Supreme Court justice in 1967, nominated by President Johnson. But it was a much younger Thurgood Marshall in 1937 who found himself not in front of the Supreme Court, as I'd been showing you, but the old Montgomery County courthouse right in Rockville. There he is leaning against the front steps of what is called the Gray Courthouse in Rockville, no longer used as a courthouse. The tall building that you see in the background there, much larger modern courthouse building today. Thurgood Marshall there in the middle with two colleagues to argue a case involving teacher salaries for the public school teachers here in Montgomery County, and specifically the salaries paid to the Black public school teachers who were paid much less than the white teachers in the segregated school system of Montgomery County at the time. And this actually began a series of teacher salary cases to try to bring about equalization of the salaries, first here in Maryland and then moving further south. As it turns out, these cases were all part of a strategy leading up to Brown versus Board of Education to try to attack segregation in any way possible. And teacher salaries were one way of doing that because the salaries were part of the budget, part of the public record. And so they had those numbers as facts and figures in black and white, as it were, written down. Now, the Brown, I keep saying Brown versus Board of Education, but the full name of the case was Brown versus Board of Education of Topeka, Kansas. Kansas, almost smack dab in the middle of the country, one of many states in which the schools were segregated by law. The case ultimately named for the Brown family. This is Linda Brown. Her father brought the case. He's the named plaintiff. But there's his daughter, Linda Brown, walking past the school for white children, actually quite near her house. She and her younger sister had to cross railroad tracks, walk much further, and actually then get on a bus and ride even further to attend the school for Black children in Topeka, Kansas. That school today is a national landmark, a national historic site, and has been restored to look like it did as a school. And you can see, looking at the two schools here, that at least in terms of the facilities, pretty equal. So in some sense, separate, but equal. Not so elsewhere throughout the South. And actually the Brown versus Board of Education of Topeka, Kansas was one of 5 cases that the Supreme Court put all together in order to make a ruling about school segregation across the South. Another case came from South Carolina. And here it was indeed both the condition of the school buildings. Here's the school that the Black children in Somerton attended. And there's the white school. So a picture is worth 1,000 words. Certainly you see the difference in facility. The other thing that prompted this case was that the school authorities provided bus transportation for the white students, but not for the Black students. And this is the case that Thurgood Marshall was most involved with. You saw in the video the whole team of NAACP attorneys. Each attorney handled a different case. Another case came from across the river from us in Virginia, a county a little west of the state capital of Richmond. There again, it was the condition of the schools, specifically the high school for Black children. The Black high school was very overcrowded. The school authorities kept promising to build a larger new school. In the end, they built only an addition to the school that you sort of see in the background there. It was derisively called the Tar Paper Shacks, a wooden addition in the late 1940s, still heated with pot-bellied stoves, if you can believe it. And so quite remarkably, the high school students here, led by the young woman in the middle there, Barbara Johns, went out on strike to protest the conditions. And then the NAACP got involved and it became part of the Brown case as well. Worth noting, because I won't really come back to the fallout from the Brown decision, but in this particular county, the county actually closed all of their public schools, both white and Black, for 5 years rather than desegregate. You probably have heard that the decision was met with massive resistance throughout the South. This was probably the strongest manifestation of that, right, in Virginia. Schools closed for 5 years, both white and Black, rather than desegregate. There you see the white high school. No trespassing. School has been closed. Another case came from Delaware on the other side of us. This was the only case that went to the Supreme Court on appeal where the lower court had found that school segregation was unconstitutional. And so it was the state authorities appealing to try to maintain segregation in Delaware. And lastly, in the nation's capital in Washington, D.C., the part of our democracy, the schools were also segregated by law. And in Washington, the case arose in Anacostia. This was a brand new then junior high school, Sousa Junior High School, built for white students in Anacostia. The Black students in Anacostia had to travel by streetcar that you see there, halfway across the city to the old Shaw Junior High School. Shaw today is senior housing, but the Sousa School is still used as a middle school in DC today. So all of those cases got bundled together under the lead case, as it was called, Brown versus Board of Education. But you could argue that the long road to the Brown decision went through the South, but actually started right here in Maryland, and specifically our own county and in Rockville, where the case was heard that I've been telling you about. So in 1936, Mr. Gibbs, there that you see top center, a teacher at the so-called Rockville Colored Elementary School, actually just a few blocks away from the courthouse, wrote to a young attorney just 3 years out of law school, who had just joined the NAACP in New York City. So Mr. Gibbs writes to Mr. T. Marshall, "Dear Sir, it is my desire to enter a lawsuit against the state of Maryland for equalization of salaries for Negro teachers." Thurgood Marshall took the case, and it was heard 1937 in the Gray Courthouse in Rockville. Now, as I said, I'm relying much on the research done recently by a professor at the University of Maryland Law School. This is Professor Larry Gibson, who has written a marvelous biography of Thurgood Marshall's early life and early career, in which this case figures significantly. And he argues that as a result of this case, you could say that Brown started right here in Rockville. There's Professor Gibson standing in front of a statue of Thurgood Marshall, which is in Annapolis, not just across the street from the State House. And there's Professor Gibson standing at what is today the Thurgood Marshall Law Library at the University of Maryland Law School in Baltimore. Now, this is quite something of an ironic honor, because Thurgood Marshall was born in Baltimore, grew up in Baltimore, wanted to attend the University of Maryland Law School quite near his house, but was unable to because the entire University of Maryland system was for whites only. No law school for African Americans, some historically Black colleges as part of the system at that time. So instead, Thurgood Marshall attended Howard University Law School, taking the commuter train, still runs today, to Washington every day. And in a way that was fortunate, because the new dean of Howard University Law School at that time, Charles Hamilton Houston, was turning Howard Law School into a real powerhouse for civil rights litigation. And Thurgood Marshall turned out to be his top student. And this photo that I was showing you of Thurgood Marshall and two colleagues leaning against the front steps of the Great Courthouse, that is indeed Charles Hamilton Houston on the left, still mentoring his former student. By this time, Charles Hamilton Houston had left Howard Law School, and he was the chief attorney for the NAACP. Mentoring his new hire, Thurgood Marshall, the third gentleman is another recent graduate of Howard Law School. But Thurgood Marshall was indeed the attorney of record for this case for Mr. Gibbs. Mr. Gibbs was paid $612, that's per year. Remember, this is the 1930s, but significantly, a white teacher in the Montgomery County school system with the same qualifications, that is the same number of years of teaching experience and the same degree, was paid almost double that amount. And that was pretty much the practice throughout Maryland. And actually, the further south you went, the larger the disparity would be. And so in December of 1936, Mr. Gibbs and Thurgood Marshall appeared before the school board to formally ask that the salaries be equalized. That was denied. And so just before the calendar turned over to 1937, Thurgood Marshall filed a lawsuit in Montgomery County Court. And the basis of the lawsuit was the very basis on which the Supreme Court ultimately decided the Brown versus Board of Education decision, the 14th Amendment's guarantee of equal protection of the laws. That is, that laws should be applied the same to everyone. Everyone should be treated equally. Now, Mr. Gibbs was actually taking quite a risk, because this was the middle of the 30s, middle of the Depression. And no one wanted to lose their job in the middle of the Depression, and teaching jobs were very valued within the African American community. But within the African American community, this was big news. Here you see the Afro-American newspaper published in Baltimore, but for all of the state of Maryland and Washington, D.C. Equal pay war opens. And this photo that I've been showing you does indeed come from the Afro-American when their reporters were here covering the case. And in fact, when the newspaper was at the courthouse, they noticed that the women's restroom near the courtroom had temporarily been designated for white women only. And so the paper editorialized that any county commissioners who set aside separate and inferior toilets for colored citizens can hardly be expected to approve of an equal salary scale. But it turns out they were a little premature in their prediction. The judge who was assigned the case, Charles W. Woodward, if the name rings a bell, we used to have a high school named for him. It was closed with the baby bust in the late 1980s. But that building that you see there on the top has recently been torn down, and a new Woodward High School is being built on the spot with increasing school-age population again. Judge Woodward, let me just summarize, because, legal cases can get very involved. But the school board filed a motion to have the case dismissed. They wanted it thrown out of court. They said that there's really no case here to be decided because separate but equal is the law of the land. But Judge Woodward actually saw a significant legal issue to be decided. And he asked for two other judges to sit in on the case with him, which was a rather unusual move. His grandson, who is also a judge today, says that his grandfather wanted strength in numbers, because as it turns out, the three judges unanimously denied that motion filed by the school board. That is, they ruled that there should be a full-fledged hearing on the case. They did not agree with the school board that it should just be entirely thrown out of court. And so there you see a much smaller headline: NAACP wins opening round in the Maryland case. It was essentially a preliminary ruling, but that ruling, Professor Gibson says, was a landmark ruling in and of itself. Says it marked the first time that any court in the nation had found that Black professionals with the same experience and credentials as white professionals had the right to equal pay. That's taken from his book. He spoke several years ago in Rockville about this case, and noted that this decision amounted to the first legal victory in the nation against any form of K-12 public school segregation, which in fact is what Brown versus Board of Education was all about. And that's why he says it all started in Rockville. Now, that is with hindsight, as I say, a more recent historical scholarship. And at the time, this preliminary ruling really wasn't remembered a whole lot, because it was overshadowed by what came next, which is that the school board agreed to settle out of court and to equalize the teacher salaries. They said they didn't have enough money to do it in the school year starting in September of 1937. The ruling came in July, as you see there. They said that they would give half the difference in the school year starting that September to the Black teachers, and then fully equalize the salaries by the following school year, the 38-39 school year. So this was a huge economic victory. Why nobody really thought too much more about the preliminary ruling. Now, why would the school board settle out of court after essentially arguing that there really was no case to be decided? There's another biography of Thurgood Marshall written by Juan Williams. You may recognize the name. Used to be a reporter and columnist for the Washington Post, now appears on television. Juan Williams writes that Montgomery County officials decided it would be better to avoid a full trial, to have that full hearing. They had no interest, Juan Williams writes, in having Thurgood Marshall lay out the inequality between school facilities for Black and white children as part of his case. And indeed, Thurgood Marshall would have had figures much like these, not quite in this straightforward form, which comes from a report done by the Brookings Institution of Montgomery County's government in 1941. But in the year that Mr. Gibbs brought his case, 1936, 1937, you can see that the county was spending about 6 times as much for the actual school buildings that had been built for the students. And the budgets were completely separate. And so that's why we have these separate numbers. And you can get a sense of that because I showed you the school building where Mr. Gibbs was teaching, a 2-story wooden frame building. That was the elementary school, means that grades 1 through 3 with one teacher on the first floor, and then grades 4 through 6 with another teacher on the second floor. But in contrast, the elementary schools being built for the white children at that time, this in fact is the old Clara Barton School in Cabin John. You can see 3 sets of windows on one side here and a center entrance, 3 more classrooms on the other side. So 6 classrooms, each grade in its own classroom. But the real measure of school spending is what we today call the per pupil expenditure, or what's actually spent on the instruction, not on the buildings themselves. And there you see again in 1936, in the elementary schools, the county spending twice as much on the white students. In the high schools, the disparity a little bit larger. So I will mention just briefly, the first high school for African Americans in our county opened in 1927. There you see it. It was actually built right next to the elementary school where Mr. Gibbs was teaching, the 2-story building in the background. By the time it opened in 1927, that was about a quarter century after a much larger high school opened as the first one in Montgomery County, not too far away in Rockville. This was Montgomery County High School, built in 1903. And by the time the African American high school opened, there were 10 high schools all around the county for white students. There you see them, and in the upper right, Poolesville High School. The African American high school, despite being 2 to 3 rooms only, and transportation not initially provided, was overcrowded almost from the start. And so in 1935, a larger high school was opened for the Black students. It was Lincoln High School. This building still stands in Rockville in Lincoln Park, the historically African American neighborhood of Rockville. But again, picture worth 1,000 words. That's a very same year. The first building of Bethesda Chevy Chase High School opened, much larger building. This building actually still stands on East-West Highway as part of the much larger BCC High School now. So as I said, the school board agreeing to equalize the salaries, a huge victory. And the Afro-American newspaper printed not only the agreement by the county to equalize the salaries, but a chronology of the case that I've been presenting here. Thurgood Marshall also saw it as a big economic victory. It will do much to raise the standard of living within the African American community. But he really wanted a legal precedent. That is, he wanted a full court hearing with an actual full ruling on the merits of the case. And so he continued this quest elsewhere in his home state of Maryland, because these are figures compiled by the NAACP showing that the situation here in Montgomery County was reflected throughout Maryland. So next, in Calvert County, he filed suit on behalf of another teacher, Harriet Elizabeth Brown. Very similar situation. White teachers paid almost double. Again, bringing the case on the basis of the 14th Amendment, guaranteeing equal protection of the laws. And again, Calvert County settled out of court, agreeing to equalize the salaries over a 2-year period also. Harriet Elizabeth Brown lived to see a roadside marker at the site of her former school, standing there with her sister, also a teacher. And a little historical trivia fact here, thanks to Professor Gibson, who notes that actually this was the original Brown versus Board of Education decision, Harriet Elizabeth Brown versus the Board of Education of Calvert County, Maryland. But again, no legal precedent. So Thurgood Marshall continued this quest. A teacher in Anne Arundel County became the plaintiff. But now Thurgood Marshall filed a case not in the county court, but on the federal level, because the state of Maryland provided some of the funding for teacher salaries so that he was able to have jurisdiction in the federal court system. And it was in a federal courtroom that, as part of this case, the Anne Arundel County superintendent at the time testified that in terms of teaching ability, his poorest white teacher was still better than his best colored teacher, and thus the unequal salaries were justified. Juan Williams, in his biography, notes that an astounded Marshall then asked the superintendent why it was that Black teachers, but not white teachers, had to scrub classroom floors. The now indignant superintendent testified with a vicious scowl. This had always been Black's work, he said. Juan Williams notes that Marshall had no further questions, took his seat. Juan Williams writes that it was a risky strategy, but Marshall, in his charming deferential way, was trying to separate the white judge from the white superintendent by exposing that superintendent as, in Juan Williams' words, a hateful buffoon. The strategy worked. And in fact, it was federal judge W. Calvin Chestnut who ruled for the Black teachers, finding that indeed the unequal salaries violated the Constitution, the 14th Amendment, guarantee of equal protection of the laws. This finally was the legal precedent that Thurgood Marshall was seeking. Now, school names become a little problematic. There is a middle school in Anne Arundel County named for that, quote, hateful superintendent, but there is also a school named for the teacher who brought the case with Thurgood Marshall's help. And as a result of that legal ruling, the Maryland General Assembly, the legislature, mandated equalization of salaries across the state. So Thurgood Marshall did not have to keep going county by county. And there's the statue of Thurgood Marshall that I showed earlier, right in front of the State House. Now, actually, it might not be Mr. Gibbs that we're remembering today, because in Anne Arundel County, even before Mr. Gibbs wrote his letter, a teacher was thinking about filing a lawsuit. Howard Pindell was his name. But it turns out he was offered a promotion. He was offered the job as principal of the Black high school in Frederick County. He took the job, but then he had tenure as a teacher in Anne Arundel County, but becoming an administrator, he gave up his tenure, and he was, in fact, fired a year later. Thurgood Marshall called it a traitorous trick. Seemed like a conspiracy among the superintendents trying to defeat the equalization of salaries. And so that is the series of cases that I've been talking about arising here in Maryland. Thurgood Marshall then continued this quest elsewhere throughout the South. But I should mention two other cases which actually came even earlier than Mr. Gibbs's case here in Montgomery County. One involves Baltimore County. And again, the year before, 1936. Remember, Mr. Gibbs' case was 1937. This was a little different. In Baltimore County, as late as 1936, there were no high schools for African-American students. Black students there who wanted to continue their education beyond grammar school had to take an exam to see if they were qualified to attend high school in Baltimore City. White students, of course, did not have to take an exam. They could just go on to high school. So Thurgood Marshall tried to enroll a young Black woman, high school student, in one of Baltimore County's high schools. This is the former Catonsville High Schools, used as an elementary school today. She was denied admission, and so Thurgood Marshall filed a lawsuit in Baltimore County. But there, the judge did indeed just outright dismiss the case. So that was a direct challenge of school segregation, much like ultimately the Brown versus Board of Education case. A very early one, Thurgood Marshall lost immediately, saw that he would have quite a tough row to hoe, as they say. So then focused on teacher salaries. In a way, he won a skirmish of the war because within 3 years, Baltimore County opened 3 high schools for African-American students. But the more significant case that is often called the first step toward Brown versus Board of Education also arose right here in Maryland, 1935, 2 years earlier than Mr. Gibbs's case. And this was a effort to enroll a Black student in the same University of Maryland Law School that Thurgood Marshall could not attend. There you see him, Thurgood Marshall on the left, arguing on behalf of Donald Murray, applying to the University of Maryland Law School. He was an honors graduate of Amherst College. And on the right, again, is Charles Hamilton Houston, again, mentoring his former student in this case. Thurgood Marshall was successful. Court ordered that Donald Murray be admitted to the University of Maryland Law School, and thus University of Maryland system was the first Southern higher education system to integrate, small way, just in the law school. But again, a huge victory for Thurgood Marshall, personally satisfying since he could not attend the law school. But as I say, it's often this case that is called the first step. Thurgood Marshall's boyhood home in Baltimore has this plaque and notes that this case involving the law school was the first victory in the school segregation fight. And signage at Thurgood Marshall's statue in Annapolis also identifies this case as the first step, as does the definitive history that I mentioned earlier. But Professor Gibson would beg to differ, saying that it really started with the Gibbs case in Rockville. Again, remember, he makes that distinction that this case involved K through 12 public school segregation, which is what ultimately the Brown decision was about. Not a law school, not graduate school, which the NAACP also brought cases about. But the NAACP had this sort of multi-pronged strategy to try to get at segregation in any way possible through graduate schools, through teacher salaries, and then ultimately the direct challenge of K through 12 public school segregation itself. There is a historical marker outside the gray courthouse, a little weather beaten, as you see. It does talk about the Gibbs case. It doesn't quite give it the ultimate significance that Professor Gibson says that it really deserves. Now, I've mentioned Charles Hamilton Houston. As I said, he was the first NAACP attorney, and as such, he pretty much devised this multi-pronged strategy that I've been outlining here. Unfortunately, he died in 1951, and so didn't live to see its results in the Brown decision. Name not as well remembered today, certainly deserves to be, something of an unsung hero. In many ways, Mr. Gibbs is not as well known, something of an unsung hero also. He was fired by the County Board of Education a year later. The county said it was not in retribution for bringing the lawsuit. Many of the Black schools still at that time were only one-room buildings. He taught in a two-room building, and as such, one of the teachers was designated to also be the principal of the school. So he was serving as acting principal, but the County Board of Education later decided, well, he didn't really have all the qualifications to be a principal, and it was on that basis that he was fired. He moved to New Jersey, finished out his career as an educator in New Jersey, returned to Montgomery County only once, and that was for a tribute dinner within the Lincoln Park community. But posthumously, he has been inducted into what is called the Montgomery County Human Rights Hall of Fame. And perhaps more importantly, a elementary school is named for him, one of the elementary schools in Germantown. We also have a Thurgood Marshall Elementary School. Now, there are many Thurgood Marshall schools around the country, but we can certainly claim his name on this one because of this very local case, but having important national significance ultimately. And perhaps the next time you're in Rockville Town Square, diagonally across from the library, or right next to the ice cream shop there, is this work of art. It is educator, leader, advocate. It is dedicated to Mr. Gibbs. It is right along what is called Gibbs Street today. And not too far away is a park bench with this newspaper, quite a large headline. I don't want to call it fake news, but it's a artist's rendering depicting the importance of the case, although there really was, other than within the Black community, no mainstream newspaper, as we would say today, with a headline quite this large, summarizing the significance of the case. Gibbs suit wins racial equity in teacher pay. So as I said, the NAACP continued this quest specifically on teacher salaries, while at the same time challenging school segregation writ large. 1938, finally, this a similar case was launched in Virginia, and then further south, took even longer, Florida, first case in 1941, first successful case, Georgia 1942, South Carolina 44. So you can see the progression here. Alabama, the case filed specifically about teacher salaries, 1947. It wasn't settled until 1955, a year after the Brown decision. And then the teacher bringing the lawsuit was fired, later reinstated by the state Supreme Court. And Mississippi, wasn't until 1948 that the teacher salaries were equalized. And again, the two teachers bringing the case, teacher and her husband, were fired. So I'm speaking here on behalf of Montgomery History. For those who are local history buffs, I've mentioned before, but Montgomery History offers virtual programs, usually Tuesday afternoons. history conversations. You can go to montgomeryhistory.org, see what's coming up, or just ask to be put on their email newsletter list, just one email a week outlining what is coming up. And so that is pretty much it. I'll stop share here.
So if we have any questions, first of all, thank you, Ralph, so much. That was like so intense, learning all that history about our local legends here.
Yes, some of our difficult history.
Yeah,
Yeah.
but
But
important
necessary to know.
nonetheless. Yes, so necessary. Does anyone have any questions they'd like to pose to Ralph at this time?
So when did Montgomery County actually desegregate the schools?
Oh, a good question. I didn't really follow through, but the Brown decision was handed down 1954. And then I did talk about the county in Virginia. But although it was a unanimous decision saying that school segregation was unconstitutional, the court recognized that it was going to, it was a fraught decision. And so they said that they would rule a year later on how it would be implemented. Wanted all the lawyers to come back and argue that specific question. And so a year later, there was what is sometimes called Brown 2, in which the court said the decision should be, schools must be desegregated with all deliberate speed. You may have heard that. It's almost a contradiction in terms. The South, generally speaking, heard deliberate, that is, take your time, consider, think about, plan, rather than speed. But Montgomery County went ahead and began the process that Brown 2 came down in May 1955. Montgomery County began the process in September of that year, mostly starting down county, because the county had started to upgrade the African-American schools, mostly wooden buildings that I showed, like where Mr. Gibbs was teaching. Finally, they were building larger brick buildings like the white schools, and that in fact is when Carver High School came along, the building which is now the administration office buildings for the county school system. They also built 4 elementary schools to consolidate the Black children in various parts of the county. There was going to be a 5th elementary school built down county, but they didn't, and then the Brown decision was handed down. And so down county, students were still attending schools in generally 2-room wooden buildings. And so that's why the county immediately started desegregating down county, because of the condition of the Black schools down county. Altogether, it was a 6-year process. The county had declared the schools desegregated by 1961. And Montgomery County was the first county in Maryland to complete that process.
Yeah, I was down in Tacoma Park in kindergarten in 61, 62. And I still recall my first grade teacher was a Black woman, Mrs. Allen. So yeah, that sounds right. Thanks.
Poolesville had a combined school in 1956, and September 1956 is when Poolesville School was desegregated.
Yes. Thanks for adding.
Anybody else have questions for Ralph?
I have one for you, Ralph, and it may be too much in the weeds, but except for that one, I believe it was Baltimore County, where the Board of Ed made the derogatory remarks about the capabilities of the Black teachers. Did any of the other Board of Educations, what was their rationale for saying in the first place that it was like that? Did they claim money was the issue, or was there never any attempt to pretty up the discrepancy, so to speak?
A little bit of a tough question. Yeah. by and large, Maryland, a southern state, historically south of the Mason-Dixon line, schools in all counties segregated by law. Not much of an African-American population in the western two counties. And so I'm actually not even sure if the schools were really segregated there. But it sounds awful to say it was just sort of the accepted practice of the times. And there were people with varying views, obviously. When Montgomery County started the desegregation process, it was controversial. There was a proposal initially that it would be a very gradual approach and only one grade each year would be desegregated. So that would have taken 12 years rather than the 6 years that I mentioned. But there were members of the school board who pushed back against that initial proposal and so went forward. So like today, varying viewpoints on so many things.
So the boards didn't even try to put up a defense, essentially.
Yes.
Okay, thank
Right.
you.
And I think I think that's fair to say by their initial motion to dismiss the case.
So I had heard, Ralph, before about how like school supplies, it definitely wasn't equal. Like, here in Poolesville, our Black schools, they would have like one dictionary, for an entire class or something. But I had never heard about the expectation of teachers and the duties that they would have to perform outside of academics. So that was like quite shocking to me to hear that it was required that Black teachers would have to wash floors of the school.
Now, let me point out that was specifically a question Thurgood Marshall asked of the Anne Arundel superintendent. I can't say whether that was the situation here in Montgomery County, other than to say, as schools move, and white schools as well, as schools move from one room to larger buildings, generally, whether it's a white school or a Black school, the one teacher in a one-room school did it all. That is, he or she would come in early in the morning to start the fire in the potbelly stove. The teacher would have to administer first aid if needed and sweep up the classroom at the end of the day, unless someone got detention and one of the kids had to do it. So generally speaking, as school systems progressed, in the early days, teachers had to do it all, and the Black schools were still pretty much rudimentary schools, much longer than the white schools.
Do you know how the early Black schools were paid for? Like I've seen something that said that the taxes that were, that we all think the schools are paid for by property taxes, that those didn't go to Black schools, that the Black schools had to actually raise their own money to pay the teacher early on, that maybe the county would supply a building if you had a certain number of children, but they wouldn't pay the teacher. And so the school year ended when they ran out of money.
Yes. Again, things changed over time. Maryland did not even mandate that the public school system provide schools for Black students until 1872. So that's what, 8 years after emancipation in Maryland, 1864. And that law specifically said that the taxes paid by white citizens would go to the white schools and the taxes paid by Black citizens would go to the Black schools.
Okay.
How long that continued, I can't say for sure, but essentially what that meant was that there was never enough money for the Black schools because of greater wealth among the white community. So yes, indeed, and I don't want to step on Maria's toes here, but next week there's a presentation about the Boyd School, so you'll hear a lot more. But yes, there were hand-me-down books in the Black schools. And one teacher was often said that at the beginning of the school year, they would take all the books that they got and try to compile as many complete books out of the the fragments of the used books that came. So yes, varying insufficient supplies. Black schools generally more overcrowded, and yes, because of separate budgets, the Black schools often closed earlier than the white schools. And there are records, I think 1904, the Black schools in Montgomery County closed as early as March for the school year.
Wow.
Because money ran out.
Yeah. I had
Not a pretty picture at all.
Yeah, not
But
our
it's-
finest hour. Yeah.
Right, it's history that we must remember.
Yes, absolutely. And we are so grateful, Ralph, to you for providing that history for us tonight and for everybody being able to have that knowledge and that understanding and how important that is to us as a community too. And speaking of which, so Poolsville seniors, as you know, this is Black History Month. We will have another presentation next week here on Zoom, 7 o'clock, about the Boyd's Negro School. We hope you'll tune in for that. And we also have fun activities, so don't forget the gala. And if you enjoy movies, we're starting to show movies now. And the next one is February 17. The title is called Dog. I think Channing Tatum stars in that. So we hope you'll join us for popcorn and socialization at Spear Hall. And again, thank you to our presenter, Ralph Buglass. Buglass, I'm sorry, I'm terrible with pronunciations. And thank you all for coming tonight and have a great week.
Thanks,
Thank you all
Ralph.
for coming.
Thank you, Ralph.
Great
Thank
presentation.
you.
Thank you,
Very good
Ralph.
night.
Thank you, Ralph.
Thank you.
so
Take care,
much.
everyone.
Night.
You can